Thank- Sorry about that. So thank you for joining me today and welcome to my presentation, Understanding Step-Parent Issues. My name is Amy Honan and I'm a Director and Accredited Family Law Specialist with Michael Lynch Family Lawyers. Just to talk very briefly about Michael Lynch Family Lawyers, we're a specialist family law firm serving clients for over 20 years now. We're one of the largest boutique specialised family law firms in the Brisbane area with 9 solicitors, 5 of them being accredited family law specialists. So today we'll be covering the most common issues that arise for step parents in a family law context. Broadly, the topics we will cover include the definition of a step parent under the Family Law Act, some statistical data in relation to the composition of the current Australian family, a summary of the legal responsibilities a step parent has, an examination of the type of parenting orders that a step parent can obtain from the family courts, an outline of the process to obtain an order for a step parent adoption in Queensland, a step parent's obligation in relation to the payment of child support, both to their own biological children and their stepchildren, if they separate from their partner, obligations for the payment of spousal maintenance, and at the end, time for some questions. There is a tab though for questions that should come up on your screen. So if something does raise interest for you during the webinar, please feel free to field any questions at that time. So what is a step parent? Under Section 4 of the Family Law Act, a step parent is defined as a person who is not a parent of the child, is currently married or in a de facto relationship with a parent of a child, or has been married or in a de facto relationship with a parent of the child, and treats or has treated the child as a member of the family. A married or de facto relationship could also include same-sex couples. Under the Family Law Act, step parents are legally defined as a relative of the child. So we've got some statistical data from October 2015, which indicates that at the time the Australian population was 23.9 million people, with 1.2 million children being aged between 0 to 17 years. Of those children, 71% lived with their 2 biological or adoptive parents, 17% lived with a single mother, 2% lived with a single father, 4% lived with a stepfather and a biological mother, 1% lived with a stepmother and a biological father, and 2% had other circumstances. So if we're looking at those 5.2 million children, 5% were in a step parent environment. So when we turn now to the step parent's legal responsibilities, parental responsibility under the Family Law Act means all duties, powers, responsibilities, and authority by law parents have in relation to children. A step parent does not automatically have legal parental responsibility for their stepchild and does not attain it if they no longer are the child's, does not retain it if they're no longer the child's step parent. This means a step parent can't legally authorise any medical care, sign school enrolment forms or other forms with the school, apply for a child's passport and so on. There is, of course, an exception for any medical situation that may arise where the step parent may be the only adult present to give consent for a procedure if the biological parents aren't there. If a partner unfortunately dies, a step parent does not automatically get parental responsibility for their stepchild. Parental responsibility will pass to the stepchild's surviving biological parent. There is, however, 2 ways that a step parent can obtain parental responsibility. That's either through a parenting order through the family courts or going through an adoption, and we'll go into some more detail now about both of those. A step parent could apply to the family courts for orders for full parental responsibility, meaning that the step parent would have all the responsibilities and authority of a biological parent. However, when a step parent would be ordered parental responsibility would ultimately depend on the facts of the case, including if there were already family court orders in place or the extent of the other biological parent's relationship with the child. A step parent has standing to bring an application under the Family Act for a parenting order, as they're a person that are interested in the care, development and welfare of a child. So in addition to parents and grandparents, if you are a person who is interested in the care, development and welfare of a child, which is usually a step parent or another relative, you can bring an application to the court for parenting orders. If both biological parents are spending time with the child and exercising their parental responsibility, it's my experience the court will be very reluctant to make orders in favour of a step parent, particularly for parental responsibility. The court could make orders, though, for specific arrangements. For example, the step parent could obtain a parenting order that allows them to receive school notices or reports or other correspondence that goes to parents, obtain information about their stepchild's education and health, orders that allow them to pick up the stepchild from the other parent on behalf of the biological parent, or orders that might allow them to spend time and communicate with the stepchild. The most common circumstances where a court will grant orders naming a step parent, in my experience, has been when the step parent's partner has unfortunately passed away, i.e. one of the child's biological parents. The other biological parent does not communicate or exercise any parental responsibility or time with the child, or in circumstances where a step parent separates from their partner and has had a long-term relationship and bond with that child, and they seek specific orders from the court to continue to have a relationship with their stepchild. Depending on which court the application is filed in will depend on who is required to participate in the family court proceedings. This is because the Family Court and the Federal Circuit Court have separate court rules. If proceedings are in the family court, then all biological parents are required under the rules to be a party to the court proceedings. The Federal Circuit Court, the other court that deals with family court matters, does not have this requirement, and the biological parents are only required if the court considers it necessary. This recently occurred on one of my matters where a step parent separated from my client who is the mother. Court proceedings were in the Federal Circuit Court, and there were two children, one the child of the mother and one who was biologically the child of the parties. The stepfather filed an application seeking orders in relation to both of the children. The stepchild was now 10 years of age and had not spent any time with the biological father since she was 4 months old. She'd known the stepfather to be her father figure since she was around 10 months old. In that case, given the stepchild's age at the time of the parties' relationship commencing, that the biological father had not had any time with the child since she was 4 months old, and that there was a history of domestic violence between the biological parents, the court dispensed with the need to serve the biological father with the court documents or make him a party to the proceedings. Insofar as the ultimate outcome in that case, it's still ongoing at this moment, so I can't give any feedback about ultimately what the court has ordered. There are two ways a court can make a parenting order, though. It can either be by consent, if there's an agreement between all the parties as to what the care arrangements would be, or the other way a court can make a parenting order is after a trial, where they will need to determine what's in the children's best interests. So when the court is determining what the children's best interests are, they are the most important consideration for the court, for parents and any step parents. The Act, the Family Law Act, specifically provides in Section 60cc the considerations when determining what a child's best interests are. These are known as the primary considerations and additional considerations. The ones up on your screen now are the primary considerations. Firstly, the court needs to weigh up the benefit of the child having a meaningful relationship with both parents. And the second primary consideration is the need to protect the child from physical and emotional harm and family violence. The Act specifically says that if there is a conflict between these two primary considerations, the need to protect the child from harm will take priority over the benefit of a meaningful relationship with both parents. As one of the primary considerations that the court has to look at is the child having a meaningful relationship with both parents, not extending to a step parent. This is part of the reason parenting orders for step parents are quite rare from the family courts. Section 60cc also sets out 13 additional considerations that the court must take into account, and some of them are up on your screen now, not the whole 13 of them. But when they're looking at the child's best interests, they must look at, the child's wishes and views, the capacity of each of the parent to provide for the child's care, the extent to which they have been involved in the child's life and taken an interest in the child's life, and their attitude to the responsibilities of parenthood. So these considerations essentially say that if there's anything specific to the child's circumstances which are relevant to what's in that child's best interest, it should be taken into account by a court when determining a child's best interests. We'll now move on to talk about step-parent adoptions, which is another way we could look at formalising some arrangements for step-parents. So if a step-parent adopts their stepchild, they will become their stepchild's legal parent. Adoption cuts all legal ties between the stepchild and their other biological parent and extended family. Adoption of a stepchild. Oh, sorry, we've got a question. I'll grab this one here. We're having a little technical difficulty. So we've got, do you have to make a specific application to dispense with that service of the biological parent? Insofar as that one, Danielle, so with that one, it was before Judge Spellican, and in that case, she was minded because both the stepfather and the biological mother didn't want to have the biological father as part of the proceedings, and so submissions were made to the court that orally, rather than a specific application, for him to be dispensed with the needs. So it had some quite unusual factors in that one. The usual course would be for a formal application to be made, but the biological father in that case had been contacted by Facebook that there were proceedings by the stepfather, and he hadn't taken any steps to contact anyone to progress the matter. So on that basis, Judge Spellican was minded to not have to serve him with the documents because he had some knowledge that the proceedings were currently before the court. So I'll move back now to the step-parent adoption. So adoption of a stepchild usually only occur in certain circumstances. For example, when a biological parent has died or isn't actively in that child's life, or the court thinks it's in the stepchild's best interests. Courts usually only grant adoption orders when parenting orders aren't enough to protect a child's welfare. So just some historical data in relation to the history of step-parent adoptions, and I'll be speaking about them today in a Queensland context because unlike family law, where we're looking at parenting orders being a federal piece of legislation, due to the way the Constitution is drafted, adoptions are dealt with differently state by state. But historically in Queensland, it was fairly common for children in step families to be adopted by their step parents. Between 1967 and 1977, 3,585 children were adopted by their step parents in Queensland. During this time, there was also no alternative options for parents seeking to secure in law a child's relationship with his or her step parent. Step-parent adoptions were viewed as a simple and permanent solution to resolve past relationship, sever contact with a non-custodial parent, and you'll hear me use this term custodial and non-custodial parent, which is an obsolete term now, but it'll assist in understanding who the players are when I'm talking about adoption, and that establish a legal recognisable family unit, provide a safe environment for a child and strengthen a new relationship. Since the introduction of the Family Law Act in 1975, which provides for custody and guardianship, again using the old terminology, arrangements for children whose parents have separated, the use of adoption to legally formalise family relationships is now quite rare. Many step families now formalise family relationships in other ways. In most instances, this will be through primary and non-primary care parents reaching agreement about the ongoing care of their children and the role of the step parent in the child's care through family court orders. So why will people look at seeking a formal adoption to cement a step parent's role in a parent's life? The main reason a blended family may seek advice is when, as I said earlier, the other parent has died. Unfortunately, the child's other birth parent has been absent for many years, and the biological parent wants to ensure that the child can remain with that step parent should anything happen to them. The parents or a child wishes to change their surname, the child's surname to the step parent's surname. To allow the child to share inheritance rights with children born in the new marriage or relationship, or that the child may have expressed a wish for the adoption. Family lawyers, I'm a family lawyer who sees any client with step parent adoption inquiries and have now assisted a number of families to complete full step applications. So when a client will come speak to me, we'll have a discussion in regards to the alternate options to step parent adoptions, because sometimes what they're looking to achieve may not be going through the formal adoption process. And me explain to them that the adoption is just one option for the child to secure a place in the newly formed family. So most commonly, I will see that one of the main reasons they think they need to go through the adoption is because they're wanting to look at changing the child's surname. And some families may feel uncomfortable if the child has a different family name of other members of family, particularly if the step parent and the biological parent now have children of their own. So if the child was born in Queensland or overseas, an application can be made to the local magistrate's court for a change of a child's surname. If the child born in another state in Australia, then they'll need to make the application through that local court. The application to change the child's name will need to be made by the biological parent with a supporting affidavit from the step parent is usually my recommendation. Their affidavits will set out a history of their relationship and why it is in the child's best interest to have their surname changed. The other biological parent will need to be served with the application, or if they're unable to be located or there's safety risks, an application to the court to dispense with the need to serve the other party will need to be made. The magistrate hearing the application will consider a variety of matters when determining the application, including wishes expressed by the child, any effect which a change of surname may have on the relationship between the child and the parent whose surname the child has had during the relationship. If a child has informally used their step-parent's surname, once they turn 18 years, they can formally apply to the Registry of Births, Deaths and Marriages to register a change of surname. If there's some estate planning issues in regards to a stepchild, it should be noted that step-parent doesn't have to include their stepchildren in their will, but if they want to provide for their stepchildren, they must be named in the will. If a stepchild is not named in the will, they could contest the will after the step-parent dies, but this does not guarantee that they would succeed. The child's biological parent and step-parent may make provisions in their wills to ensure that they have a right to future inheritance from the step-parent. Parents can also safeguard their child's future by nominating a step-parent as the future guardian of the child in their wills or in the event of their deaths. In Queensland, this, however, is not legally binding, and an application to the family courts for parenting orders in favour of a step-parent may be necessary if there's a dispute between a biological parent and a step-parent as to the ongoing care arrangements for the stepchild. Other options to secure the relationship between the step-parent and stepchild include counselling for the child to make them feel more secure in the blended family, or, as we discussed earlier, an application for parenting orders from the family courts. So let's get more now into the process of doing a step-parent adoption in Queensland, and there's two steps that are required. The first step is that an application must be made to the family court for leave to commence step-parent proceedings. Once the leave has been granted by the family courts, in Queensland, an application is then made to the Adoption Services Queensland, which is a service that's part of the Department of Communities, Child Safety and Disability Services. This legislation's only been in place since 2009 when the Adoption Act was amended. An application by Adoption Services Queensland will not be progressed or accepted until an order from the family court and granting leave to the parties has been made. So how do you be an eligible step parent to apply for adoption? So there's a number of factors that need to be, or boxes that need to be ticked. So the first one is that the person has lived with the child and the birth parent for at least 3 years continuously, that person is an adult who is resident in Queensland, that the person is an Australian citizen or the spouse or partner of an Australian citizen, that the person has been granted leave by the family court, and the child is older than 5 years but younger than 17 years. An application in relation to a child who has turned 17 but is not yet 18 may be accepted in some circumstances, but this is only if the Adoption Services Queensland are satisfied that there's enough time to complete the process before the child turns 18 and the grounds for making an adoption order are likely to exist. The Queensland legislation was recently amended, so now same-sex couples can apply for a step-parent adoption as long as they meet the above eligible requirements. Prior to this amendment, it was clear that same-sex relationships could not be considered. The application form sets out a number of documents that need to be provided as evidence for the eligibility requirements. Some of the documents include, noting this isn't an exhaustive list, as a copy of the family order from the family court confirming that leave has been granted, copies of documents that prove that step parent is a resident of Queensland, for example, a rates notice, signed lease agreement, a Queensland driver's licence, identification documents, so 2 of those, including a driver's licence, a passport, pension card, Medicare card, a full copy of their birth certificate of both themselves and the biological parent, so their spouse or partner, the child's original birth certificate. The original certificate is required as Adoption Services want to take their own copy for certification, but once they've made that certification, they'll return the original certificate to the parents. A full copy of any marriage certificate if the parties are married, or if they're not married, the Adoption Services Agency will require a statutory declaration stating the length of time the parties have lived together as a couple, and if possible, copies of documents that provide evidence that they've been living together for at least 3 years. So joint names on a mortgage document or documents that show that they've resided at the same address. So for example, perhaps a lease agreement. An application for leave must be filed in the family court, and the family court has exclusive jurisdiction for adoption matters, so the application cannot be filed in the Federal Circuit Court. It's important to note that even if leave is granted to a step parent, it does not automatically imply that an adoption order in the step parent's favour will be made by the state court. It seems a little ridiculous, one court granting leave so another court can decide. Indeed, even the family court judges consider this two-step process to be extraordinary, with one judge saying, it is somewhat odd that it's necessary to apply to one court for leave to apply to another court for an exercise of the latter court's original jurisdiction. Nevertheless, that is the consequence of the Family Law Act. So until the Family Law Act is amended, and I don't think it's high on the priority list with other amendments probably being pushed further at the moment, the process in obtaining the leave from the family court is going to remain necessary if you're looking for a step parent adoption. So let's go a bit more detail into the process. So the application's filed with the family court with both a step parent and birth parent who's the partner or spouse of that step parent, as applicants in the application. So you'll have the step parent as applicant 1, the biological parent, their partner, as applicant 2, and then the other biological parent as respondent. Attempts will need to be made for the respondent to be served with the application, and if they can't be located or another reason exists, ones that we've talked about earlier in the webinar, they've passed away or there's safety concerns, the court can dispense with the requirement to serve them with the application. Once the respondent has been served or orders have been made to dispense with the need to serve a party, the matter will be listed before a judge for hearing. When the judge is determining whether it should grant leave, it must consider whether granting leave would be in the child's best interests, taking into consideration the factors under Section 60cc of the Family Law Act, which we went through earlier in this presentation. So the 2 primary considerations and the 13 other considerations. In addition to those, the court must consider the effect of the adoption on other birth parents' parental responsibility and whether any previous parenting orders have been made. It's my experience in the number of step parent adoption applications I've done now that most applications for leave are granted by the family court, and many are unopposed by the other biological parent. Applications are made when biological parents have passed away or have had no involvement in a child's life for a significant period of time, and they do not seek to have any relationship with the child moving forward. To apply for an adoption of a stepchild, once we've got the leave, the step parent will need to complete an application to adopt a stepchild form, which must be completed and returned to adoption services. So a lot of documents need to be accompanied with those forms, and some of them we went through earlier in the presentation. A step parent is required to submit a separate application for each child they're seeking to adopt and pay a separate fee for each application. Only the step parent seeking to adopt the child is required to lodge the application. So a little bit different to the family court proceedings, where both the step parent and the biological parent will be required to be applicants. In the second stage of the application process, only the step parent needs to be on the form. However, the child's biological parent that the step parent is with is required to sign the form, and any other adult residing in their home at that time, so an aunt, uncle, or a grandparent, or perhaps an adult child of either of the parties' relationships, would have to sign the application form. The application form must be submitted with the payment of an application fee, which is currently $83.95, as is to be expected with both government agencies. It clicks over slightly on the 1st of July every year, so that is likely to change in a few months. So the next step would be is the Adoption Act requires each of the child's biological parents to consent to the adoption before the application can proceed. This is regardless of what occurred in the application to the family courts to obtain leave. So even if the biological parent, the other biological parent, I should say, consented or didn't show up or anything, it's like going through the whole process again. If the other biological parent does not wish to give consent or can't be located or their identity cannot be established, then adoption services cannot continue with the application. If a step parent wishes the application to proceed without consent, they'll need to make an application to the Children's Court for the dispensation of the need for that parent's consent to the child's adoption. It's the step parent's responsibility to apply for an order dispensing with the need of consent. If it is opposed, if they're not, so I said the reasons they would do it if they're not engaging the process or can't be located. The Children's Court may also make an order dispensing with the need for a parent's consent where there's an unacceptable risk of harm to the child or the mother or the father, or if the parent becomes aware of the child's, if the parent becomes aware of the child's birth and proposed adoption. So once the consent has been either given or dispensed with, the next stage we'll move into is the assessment progress. Assessment progress. A step parent who meets the eligible criteria and whose application has been accepted must be assessed to determine their suitability to be the child's adoptive parent, and that the adoption is in the child's best interest. So we've got another fee that's paid to go to the next step, which is currently $629.90. But again, government department likely to be increased on 1 July in a few months. The assessment is a complex process conducted by an Officer of Adoption Services Queensland that involves all members of the family, including the step parent, the custodial parent, the child, and the child's siblings. They'll interview members of the family and the child who's subject of the adoption application. Usually this will occur by the house, the residents. They may also contact the principal of the school and see how the child's going. They also may require the parents and the child to attend their offices in the city if the matter's filed in Brisbane anyway. Although the child's not required to give his or her consent, adoption services will talk to the child in an age-appropriate manner about his or her views of the adoption. Some of the information considered in the assessment includes the step parent's personal history, including whether there's any criminal, domestic violence, child protection and traffic history, the current health of the step parent, the personal references that the biological and step parent are able to provide for each of them, the family profiles, the views of any significant relatives, the family's motivation for making the application. For example, what does the family believe the adoption will offer that the current status quo or alternatives to adoption cannot? The step parent and parent's understanding of the adoptive parenting and the effect of making an adoption order and possible implications for the child in the future. The step parent and parent's expectation of adoption and what adoption will mean for their family and their family relationship. The length of time the step parent has been responsible for and cared for the child, and the nature, closeness and quality of the step parent's relationship with that child, and the home environment and family dynamics, including the quality of the relationship between the step parent and the child. Upon completion of the full assessment, the adoption officer will provide an assessment report to support the decision-making process. A preliminary assessment suitability report will be given to the step parent, and the step parent and parent have 28 days to provide feedback on the report before it is finalised and a decision is made about the step parent's suitability to be the adoptive parent. If the step parent is assessed to be a suitable adoptive parent, Adoption Services provides a final report for the Children's Court stating that the step parent is suitable and to consider it for an order for the child's adoption by the step parent if the court consider it best serves the child's interests. So once we've got the final report issued, the step parent and the custodial parent will then themselves make the application to the Children's Court for an adoption order, and the Children's Court will then consider if the required matters are met to make an adoption order. Whilst Adoption Services Queensland may have assessed the step parent as suitable before making a final adoption order, the court needs to be satisfied that the order promotes the child's well-being and best interest better than any other order, and there are exceptional circumstances that warrant the making of the order. Depending on the age of the child may attend the Children's Court on the day of the hearing with the parent and their step parent, and the magistrate may ask some questions to the child to work out whether they understand the process and whether it's consistent with their views. But this will depend on the age of the child and the magistrate hearing the matter. So after all that process, if an adoption order is made, the adopted child becomes a child of that step parent, and the step parent becomes the parent of that child. The adopted child ceases to be a child of the non-custodial parent, and the non-custodial person ceases to be a parent of that child. Adoption permanently transfers the legal rights and responsibilities of parenthood from a child's non-custodial parent to his or her adoptive step parent. So that parent would no longer be, for example, required to pay any child support, have any parental responsibilities in regards to issuing of passports, etc. Following the making of an adoption order, adoption services will authorise the Registry of Births, Deaths and Marriages to issue a new birth certificate for the child, which will list the step parent as either the father or mother of the child, depending on the gender of the step parent who's made the application. The process isn't a quick process, as you can see from the number of steps we've gone through above, and this is understandable given the permanent nature of an adoption order. My experience from my most recent application has been it will take anywhere between 3 to 9 months to get the leave through the family courts, and that's usually the most straightforward process, but still there's delays in the family courts, so that's going to take a while, and it could take anywhere from 1 to 2 years through Adoption Services Queensland to undertake the suitability process. If the child's young, the process will take longer, as they're likely to not prioritise it, particularly given the permanent nature of an adoption order. They're likely going to prioritise children who are seeking a step-parent adoption in their teens, so it can be finalised before the child turns 18. The process, again, could take longer if there's difficulties with obtaining consent from the biological parent, and applications to dispense with the biological parent's consent is necessary. So what happens if the step-parent separates after an adoption order is made? So although a marriage may dissolve after an adoption order has been made, the dissolution of the marriage does not provide grounds for an adoption order to be discharged. A step-parent who adopts his or her stepchild continues to be that child's legal parent permanently. Parents need to be aware of this when they're considering a step-parent adoption of a child, that there are legal consequences and the lifetime implications of the adoption. And this is definitely something Adoption Services Queensland goes through with both the parents when they are when they're completing their suitability report. So I'm going to get a little bit personal now in regards to why I love step-parent adoption. So as I said earlier in my webinar, at Michael Lynch Family Lawyers, I'm the family lawyer who sees any client with a step-parent adoption inquiry. I've now assisted a number of families to successfully obtain leave from the court leave from the family court to commence step-parent proceedings, and most times step-parents will go through the second stage through Adoption Services themselves, as they're very user-friendly and really help parties through that process. But I divert. Why I have a special personal interest in these matters is I was adopted by my own dad. Oh, I'm getting emotional even talking about it. So my parents met when I was 4 years old, and I've just always thought as my stepdad as my dad. It was only when I was in my first year of law at the age of 17 that I discovered adoptions need to be completed before a child turns 18. I approached my parents about wanting to make things legal, and we made an application. The process in my case was pretty straightforward. At the time, didn't require for you to get leave from the family court, and I was 17. It was pretty after an interview with my caseworker and a few other steps, the order was granted and my birth certificate was reissued. In my first step-parent adoption matter at Michael Lynch Family Lawyers, my client was a stepfather and a mother of a child. The mother involved a number of additional steps, as the child's birth father spoke limited English and lived in China. After the family court granted leave, the father initially indicated to Adoption Services Queensland, because I had to get his consent again, even after we've got the leave, that he would consent to the adoption. And some process was underway and some translating was going on. However, ultimately, he wasn't responding to phone calls from the caseworker. And apparently, it was apparent that the language barrier was just too much for him, and he just didn't want to be involved. So it became necessary to apply to the Children's Court to be able to proceed without his consent. Given my long-term relationship with the parties. They engaged me to help them with making the application to the Children's Court, and I appeared on behalf of my clients and successfully obtained an order to dispense with the requirement for the father's consent. In a funny twist of fate, I was surprised at court to see the caseworker assigned to my client's case was the same caseworker who had handled my own adoption application 12 years earlier. Sorry, that's getting me quite upset. It's just a wonderful memory. The caseworker remembered my aspirations in my interview about being a lawyer and was pleased to see that I was one. Ultimately, I've had the privilege of seeing my clients' cases from the initial family court application to the day the Children's Court granted the final adoption order. And in that one, there was some other complicating factors with the biological mother getting breast cancer through the suitability process as well. So that adoption order took 3 years to go through. But I attended at the Children's Court with them on the day that the adoption order was made. And yeah, it was a really special time. So anyway, if you want to read a bit more about it without me getting choked up and emotional, I've got a blog, the name of which is up on the screen at the moment. So I blog as the Trailblazing Lawyer. So there's some practical tips on there for your clients or yourself if you're going through it as well, and a little bit more about that story without the wobbling voice going on. So let's move on. Okay, so let's move on about child support now and supporting a stepchild and what the court says. So the court's made it clear that there's no automatic legal duty to maintain a stepchild. The court's even gone so far to say that the duty of a step-parent is secondary to that of a biological parent. Some case quotes there. So what happens if the parents separate? So this is talking about a step parent and the biological parent. So the Department of Human Services Child Support, more commonly known as the Child Support Agency, and that's how I'll refer to them now because it's a little bit easier off the tongue, is a department that decides what support should be paid for a child using a formula to calculate the amount of child support to be paid. They then issue what's known as an administrative assessment that sets out the amount to be paid per week. The Child Support Agency cannot order a step-parent to pay child support for a child. Only a court, so a family court or a federal circuit court, can order a step-parent to pay child support for their stepchild. So a step-parent's duty to pay child support for their stepchild always comes after the duty of a child's biological parent to support the child. But if an application is made by a biological parent to seek a step-parent to pay, the court would have to look at how long the step-parent and the stepchild's biological parents were in a relationship or marriage and what kind of relationship it was, what kind of relationship the step-parent had with the stepchild, whether the stepchild receives a proper level of financial support from their biological parents, and how the stepchild was financially supported during the relationship with the biological parent. The court can also look at any other special circumstances that, if they're not taken into account, could make life hard for anyone involved in the situation. If a parent has a relevant dependent child in their care, the costs of the parent caring for that child is taken into account when using the child support formula to calculate the child support they are required to pay. The costs are included by deducting a relevant dependent child's amount from the parent's initial child support income. If a step-parent has biological children of their own and is required to pay child support, there are certain circumstances where they can ask the Child Support Agency to class their stepchild as a relevant dependent, which will usually result in a reduction in their administrative assessment to pay child support. A registrar of the Child Support Agency can treat a stepchild as a relevant dependent child of a parent in a child support assessment if the court's made an order requiring that step-parent to provide financial support for the stepchild and the parent has at least shared care of their stepchild. From 1 July 2008, the agency has streamlined this process, though, where the registrar can treat a stepchild as a resident parent of a parent, a step parent, if no one else can financially support that stepchild. For example, the other biological parent is unknown or has passed away, or is overseas and is unable to pay any child support because they may live in a jurisdiction that isn't a reciprocal jurisdiction for child support purposes. This means that that parent may be able to have their stepchild considered administratively when calculating child support without the requirement to obtain a court order. The last topic we're going to talk about today is about spousal maintenance. This area is probably the least likely to affect a step parent, however, something that may occur if the step parent separates from their partner. Spousal maintenance can be ordered after the breakdown of either a de facto or relationship or a marriage, and unlike child support, there's no formula or an agency established to calculate the maintenance required to be paid, like there is with the child support agency we just spoke about, and whether spousal maintenance is required to be paid, and what is required to be paid will change in each matter. There's strict timeframes, though, for spousal maintenance applications. For parties that have been in a marriage, the limitation date is 1 year after a divorce order issues. Parties must be separated for 12 months before they can apply for a divorce, but the limitation date or the clock doesn't start ticking until they've actually applied for the divorce. For people in de facto relationships, however, the limitation date starts the day they separate, and they have 2 years from the date of their separation to bring an application for spousal maintenance. If there is a final or interim spousal maintenance order in place, there's no limit for a party to apply to vary a current spousal maintenance order. So we look at 2 steps when we're looking at making when the court's looking at making a spousal maintenance order. And the first step is to look at the needs of the applicant, being that they cannot support themselves from their own income due to the care and control of a child of the relationship. You can see that relationships in bold there, so it's not talking about stepchildren, it's talking about biological children under 18 years. That party's age or physical or mental health or any other adequate reason. As the Act's clear that it's a child of the relationship, it's not going to extend to a stepchild. An argument, however, could still be raised that spousal maintenance is needed as the case of a stepchild could fall under any other adequate reason, and that would really depend on the facts of the case and the time that the step parent had been involved in the stepchild's life and the extent of the financial support that they provided to that stepchild during the course of the relationship. Even if an applicant for spousal maintenance is able to show that they have a need for spousal maintenance, court can only look at making an order if the respondent has capacity to pay some of all of the maintenance sought. So we're looking at what the respondent's reasonable expenses are, and does their income meet their reasonable income, or at the end of the day, do they have some surplus left to pay the spousal maintenance to the applicant after they've met their necessary commitments. So when we're looking at spousal maintenance, there's a number of factors that the court will look at as well in weighing those up. Some of the ones that might be more relevant in a step-parent context have been bolded in the slide. So we're looking at whether somebody has a commitment to a duty to maintain another person. So it says a child or another person, so stepchild could fall under another person. The need to protect a party who wishes to continue that party's role as a parent, that again could extend to a parent wanting to continue to care for their step child, and also it has to weigh up whether there's any child support being provided or is required to be provided. So I'll just give some time whether there's any questions to go through it all. It's been quite some detailed content today. Lots of it's on the slides as well. Understand that there may also be some questions that people might think of in the coming days. So more than to those three, so as any kind of particular questions in regards to your client or some clarifications in regards to the process. I guess my feedback would be, insofar as getting family court orders or adoption service, Queensland giving an adoption order, they are quite lengthy applications to make and quite difficult. They're not the common inquiries that we receive all the time, or adoption as a way for a step parent to be able to have some cementing the relationship with their child. We'll be sending through a feedback survey after the webinar today. Any feedback would be greatly appreciated. Me not bursting into tears, telling an emotional story, I'll take that feedback as well. It's obviously my stepdad's close to my heart, and talking about him does make me quite emotional. But yeah, we've just some information on the last slide. Is just some details about our firm. If you have any clients or think somebody would benefit from a general family law matter, or even something like some more particular information in regards to their step parent situation, we do offer a fixed fee consultation. We have two rates here, $385 including GST for a solicitor or associate, or if your client is interested in seeing an accredited specialist, a rate of $440 including GST. Details on this as well. There's an opportunity for our family flyer that issues once a month, which will have some really interesting and keep you up to date in regards to family law matters. And also earlier in the slide, my